The envelope arrived on a Thursday. Return address from county records office. I almost threw it away with the junk mail, assuming it was another property tax notice. But something made me open it. Inside was a photocopy of my house deed. My house, the one I'd lived in for 43 years, the one my husband and I bought with our first down payment in 1982. Except the names on the deed weren't quite right. Primary owner, Matthew Whitman. Secondary owner, Catherine Whitman. Previous owner, Betty Whitman. Previous owner, as if I'd sold it, as if I'd signed away the house where I raised my son, buried my husband's ashes in the garden, lived through joy and grief and every ordinary day in between. My hands shook as I read the transfer date 6 months ago, April 15th, a date I remembered for other reasons, tax day, the day I'd been recovering from a bad flu, the day Matt and Kate had come over with soup and paperwork they'd said was for my estate planning. I'd signed papers that day, barely reading them, too foggy for medication to focus. They'd assured me it was just updating beneficiaries, making sure everything was in order in case something happened to me. In case something happened. That phrase, so kind on the surface, so sinister underneath. My name is Betty Whitman. I'm 68 years old, retired pharmacist, widow for 5 years. I spent 39 years filling prescriptions and counseling patients about drug interactions and side effects. I know how to read fine print. I know what questions to ask. But on April 15th, sick and tired and trusting my son, I'd signed without reading. And now I was the previous owner of my own house. I called Matt immediately. He answered on the third ring, voice bright and casual. Hey, Mom, what's up? I received something from the county records office about the house. A pause, brief but telling. Oh, that. Yeah, we were going to mention it. Mention that you transferred ownership of my house into your name. It's not like that. It's just for estate planning. Your lawyer suggested it. Remember? I don't have a lawyer. I had your father's old attorney, and he retired 3 years ago. Well, Kate's cousin is an attorney. He said it was the smart thing to do to avoid probate. When when the time comes. When I die. He couldn't even say it directly. Matt, if you wanted the house after I died, you could have just said so. You didn't need to transfer ownership while I'm still living in it. Mom, you're overreacting. It's still your house. You're still living there. Nothing's changed. Except my name is listed as previous owner. That's just legal terminology. It doesn't mean anything. But it did mean something. It meant on paper, legally, Matt and Kate owned my house. I was just a resident, a tenant in my own home. I want it changed back, I said. Mom, that's complicated. There are tax implications, legal fees. It's better to just leave it. It's my house. And one day, it'll be mine. This just makes the transition smoother. The transition, I'm 68, not on my deathbed. He sighed. That particular sigh, adult children use when they think their parents are being unreasonable. Look, Kate and I can come over this weekend. We'll explain everything. You'll see it makes sense. I don't need you to explain. I need you to transfer the deed back into my name. Mom, please don't make this difficult. I hung up, sat at the kitchen table, the county records photocopy spread in front of me like evidence at a crime scene. The signature at the bottom looked like mine. The loops and curves matched my handwriting. But I didn't remember signing it. I pulled out my files, the ones I kept in the hall closet, in a fireproof box, birth certificates, marriage license, the original deed from 1982 when Richard and I bought this place. I found it at the bottom, yellowed paper, my maiden name and Richard's name in careful typewriter font. That was the real deed, the original proof of ownership. Whatever Matt had filed with the county was a copy, a modification, a lie dressed in legal language. I needed help, not from Matt, not from Kate's cousin, the attorney, from someone I could trust. I called Joyce, my friend from the pharmacy days. We'd worked together for 20 years before I retired. She was the kind of person who asked hard questions and expected honest answers. Betty, you sound upset. What's wrong? My son transferred ownership of my house without my permission. What? How? I signed something when I was sick. He said it was estate planning. Turns out it was a property transfer. She was quiet for a moment. Then, that's fraud, Betty. If you didn't understand what you were signing, that's coercion. You need a lawyer, not his wife's cousin, a real one. I don't even know where to start. I do. My sister went through something similar with her daughter. Let me get you the name of her attorney. Within an hour, I had an appointment scheduled with a lawyer named Donovan Pierce, real estate and elder law specialist. Joyce's sister said he'd saved her house and her sanity. I just hoped he could save mine. That weekend, Matt and Kate came over as promised. They brought wine and a folder full of documents. Kate was dressed like she was going to a business meeting. Tailored blazer, confident smile. Matt looked nervous. We sat at the dining table, the same table where we'd had family dinners for decades. Now it felt like a negotiation table. Kate opened the folder, pulled out papers. Betty, we wanted to walk you through what we did and why it makes sense. I'm listening. First, this protects the house from potential Medicaid claims. If you ever needed long-term care, the state could put a claim on the property. This way the house is protected. I'm not planning on needing long-term care. No one plans on it. But it happens. She slid a document toward me. Second, it avoids probate. When you pass, the house automatically transfers to Matt without going through the court system. Saves time and money. Whose money? Yours. Well, technically Matt's at that point. I looked at the document. It was dense with legal language, clauses about reversions and life estates and beneficial interests. Terms I didn't fully understand, but that felt designed to confuse rather than clarify. And I signed this on April 5th. Yes, we were here, remember? You had the flu. We brought you soup. I remember the soup. I don't remember this. I pointed to the signature line. That's my signature, but I don't remember writing it. Matt spoke up, voice gentle. Mom, you were pretty out of it. You kept saying you just wanted to sleep. We helped guide your hand, made sure the signature was legible. You guided my hand? Well, yeah. You were shaky. We didn't want the notary to reject it. I looked at Kate. There was a notary? Of course. It's legally required for property transfers. Who? A friend of ours? Mobile notary. We called her to come to the house since you weren't feeling well. Every word sounded reasonable in isolation. But together, they painted a picture of a woman too sick to consent being walked through a legal process she didn't understand. I want to see the original document. The one with my actual signature. Kate and Matt exchanged glances. It's filed with the county, Kate said. We can request a copy. You don't have a copy? We gave you one. It must be in your files. It's not. Another glance. Then we'll get another copy from the county. It's public record. Good, do that. And while you're at it, transfer the deed back into my name. Kate's smile stayed in place, but her eyes cooled. Betty, I understand you're confused, but we can't just undo a legal property transfer because you don't remember signing it. That's not how it works. Even if I was coerced, you weren't coerced. You were sick, but conscious. You asked us to handle your affairs while you recovered. We did exactly what you asked. I asked you to steal my house. Matt stood abruptly. Mom, that's not fair. We're trying to help you. If you're going to accuse us of theft, maybe we should leave. Maybe you should. They gathered their papers. Kate's smile was gone, replaced by something harder. We'll send you the county documents. But Betty, I need you to understand something. This house is legally ours now. You have a life estate, which means you can live here until you die. But it's not yours anymore. Fighting this will just cost you money and stress you don't need. After they left, I sat in the empty house, their words echoing, not yours anymore. For 43 years, this house had been mine. The mortgage I paid monthly for 30 years, the repairs I'd funded, the memories I'd built. And now, because I'd trusted my son, it belonged to someone else. But Kate was wrong about one thing. I wasn't confused. I was clear, clearer than I'd been in years. And I was done being managed. Donovan Pierce's office was downtown 14th floor of a building with marble lobbies and expensive art. I felt out of place in my practical cardigan and sensible shoes, but his assistant greeted me warmly and led me to a conference room. Donovan was in his 50s, gray hair, sharp eyes behind wire-rimmed glasses. He shook my hand firmly and gestured to a chair. "Mrs. Whitman, Joyce's sister, speaks highly of you. Tell me what's happening." I laid out everything: the flu, the soup, the papers I'd signed without reading, the county records showing Matt as primary owner, Kate's explanation about Medicaid lanes and probate, the notary I'd never met. He took notes, occasionally stopping me to ask clarifying questions. When I finished, he sat back. "First, let me be clear. If what you're describing is accurate, this is elder financial abuse, specifically deed theft. It's more common than people think, and it's devastating. Can we undo it? Maybe. Depends on the evidence. Let's start with what we need to prove. 1, you didn't understand what you were signing. 2, you were incapacitated at the time, either by illness or medication. 3, your son and daughter-in-law misrepresented the documents to you. 4, the notary didn't properly verify your consent. How do I prove any of that? Medical records showing you were sick, prescription records showing what medications you were on, witness statements from anyone who saw you that day, and most importantly, the original deed with your signature compared to your normal signature from other documents. Kate said the original is filed with the county. We'll subpoena it. But here's the thing, Mrs. Whitman. These cases are hard. Your son will claim you knew what you were signing, that you were competent, that this was your idea. It becomes your word against his. So I might lose my house. You might, but we're going to fight." He opened his laptop. "First thing, I'm filing a notice of dispute with the county. That puts a hold on any further actions involving the property. They can't sell it, refinance it, or transfer it again without court approval." They're planning to sell? I don't know. But if they transferred ownership, it's probably not for estate planning. It's to gain control. The question is why. That question haunted me over the next week as Donovan filed paperwork and requested documents. I spent my days going through old files, looking for proof that I'd been competent, responsible, not the confused elder Kate had painted me as. I found bank statements showing I'd managed my own finances for 5 years since Richard died. Tax returns I'd filed accurately. Correspondence with doctors, clear and coherent. Every piece of paper was evidence that I wasn't the helpless woman they'd needed me to be. Joyce came over most evenings, bringing dinner and moral support. "How are you holding up?" she'd ask. "Angry," I'd say, "and scared." "What if I lose?" "Then you appeal? Then you fight harder?" "But Betty, you have to prepare yourself. This might get ugly." She was right. 3 days after Donovan filed the dispute, I got a call from Kate. "Betty, we need to talk about what you're doing." Her voice was calm but cold. "You filed a legal claim against us. That's serious. You stole my house. That's serious too. We didn't steal anything. We helped you with estate planning, and now you're having seller's remorse. But you can't undo a legal transfer just because you changed your mind." I didn't change my mind. I never understood what I was signing. "Because you were drunk." I went still. "What?" "On April 15th, you'd been drinking. Matt and I smelled alcohol on your breath. You're slurring your words. We tried to stop you from signing, but you insisted. We have the notary's statement confirming you were intoxicated, but insistent." "That's a lie. I was sick, not drunk." "That's your story. But the notary saw what she saw." "I'd like to talk to this notary." "Good luck. She moved to Arizona last month, but her statement is notarized and filed with the county." After she hung up, I sat shaking with rage. They'd created a narrative where I was drunk, incompetent, demanding to sign away my house, and they'd fabricated evidence to support it. I called Donovan immediately. He listened, then said, "This changes things. If they have a notary statement saying you were intoxicated but capable of consent, that's going to be hard to fight. It's not true. I believe you, but we need to prove it's not true. Do you have medical records from—" "I didn't go to the doctor. I just stayed home with the flu." "What about prescriptions? What were you taking?" Over-the-counter stuff. Dayquil cough syrup. Nothing that would show up in medical records. Damn. He was quiet for a moment. Okay, here's what we do. We subpoena the notary. Even if she moved, she's still bound by law to testify, and we get a handwriting expert to compare your signature on the deed to your signature on other documents. If they guided your hand, like Matt said, it won't match your natural writing. How long will this take? Months? Maybe a year? And it's going to cost money. How much? $20,000. Minimum. Maybe more if it goes to trial. I thought about my savings. The retirement account I'd built over 4 decades. I'd planned to use it for travel for grandchildren I'd never have for a comfortable old age. Now I'd use it to fight for my own house. Let's do it, I said. The next few weeks were a blur of paperwork and depositions. Donovan requested my medical history, my prescription records, even my credit card statements to show I hadn't purchased alcohol that week. Every piece of my life was scrutinized, documented, presented as evidence. Matt and Kate hired their own lawyer, a woman named Sandra Cross, who specialized in elder law from the other side. Her job was to prove I'd been competent, willing, and properly informed. The first deposition was brutal. Sandra Cross asked questions designed to make me look forgetful, unstable, prone to confusion. Mrs. Whitman, how many medications are you currently taking? 3. Blood pressure, cholesterol, and a daily vitamin. And in April, were you taking any additional medications? Over-the-counter cold medicine. Which kind? Dayquil, I think. Maybe NyQuil at night. You think? Or I think it was months ago. She made a note as if my uncertainty was proof of incompetence rather than normal memory. Do you drink alcohol, Mrs. Whitman? Occasionally. A glass of wine with dinner. How often is occasionally? Maybe once a week. Sometimes less. On April 15th, had you been drinking? No. Are you certain? Yes. Even though you were taking cold medicine that clearly states not to combine with alcohol. I wasn't drinking, but you don't remember which cold medicine you were taking, so how can you be certain you weren't drinking? The logic trap was obvious, but still effective. If I couldn't remember the medicine, how could I remember not drinking? Every answer I gave became evidence of my unreliability. After the deposition, Donovan walked me to my car. You did fine. I felt like a criminal. That's her job, to make you doubt yourself. But Betty, we have something she doesn't. What? The truth. And eventually the truth leaves evidence. I hoped he was right. The handwriting expert was a woman named Dr. Patricia Hoffman, 60s, academic demeanor, 30 years of experience analyzing documents for courts. She came to Donovan's office with a portable scanner and magnifying equipment. I need samples of your normal handwriting, she said. Letters, checks, anything with your signature. I brought a box, birthday cards to Matt over the years, checks I'd written to pay bills, the guest book from Richard's funeral where I'd signed my name dozens of times while numb with grief. She studied each signature, took photographs, made notes, then she examined the deed signature. After 20 minutes, she looked up. This isn't your natural signature. What does that mean? Your normal signature has a distinctive flow. The B in Betty is always slightly larger than the other letters. The tail on the Y curves left. These are consistent across decades of samples. She pointed to the deed. This signature is different. The B is the same size as other letters. The tail curves right. And most tellingly, there are tremors in the strokes. Tremors, like someone was guiding the hand holding the pen, or like the person signing was physically impaired. I was sick. Exactly. The signature was made by someone who was either very ill or being physically assisted. Possibly both. Can you prove that in court? Yes. I'll prepare a full analysis with overlays and measurements. This won't be subjective testimony. It'll be scientific evidence that this signature doesn't match your normal writing. For the first time since opening that county records envelope, I felt hope. But hope is fragile, especially when your opponent is willing to lie. The hearing was scheduled for a Tuesday morning in late November. I arrived at the courthouse with Donovan, my hands shaking despite the medication I'd taken for my blood pressure. Matt and Kate sat on the opposite side of the courtroom with their attorney, Sandra Cross. Matt wouldn't look at me. Kate's expression was neutral, professional, like this was just another business transaction. The judge was a woman in her 60s, Judge Maria Kensington, with gray hair and a reputation for fairness. She read through the case summary, then looked at both attorneys. This is a dispute over property transfer. Mrs. Whitman claims she was coerced into signing the deed. Mr. and Mrs. Whitman claim the transfer was voluntary and properly executed. Miss Pierce, you filed the challenge. Present your evidence. Donovan stood. Your Honor, we'll demonstrate 3 things. First, Mrs. Whitman was incapacitated at the time of signing due to illness. Second, the defendants misrepresented the nature of the documents. Third, the signature on the deed is inconsistent with Mrs. Whitman's normal handwriting, suggesting coercion or impairment. He called me to the stand first. I swore to tell the truth, sat down, tried to keep my voice steady. Mrs. Whitman, can you describe your condition on April 15th? I had the flu, high fever, body aches, difficulty focusing. My son and daughter-in-law brought me soup and said they had paperwork for me to sign. Did they explain what the paperwork was? They said it was for estate planning, updating beneficiaries, making sure everything was in order in case something happened to me. Did they mention transferring ownership of your house? No. If they had, would you have signed? Absolutely not. Sandra Cross objected. Speculation. Sustained, the judge said. Donovan changed approach. Mrs. Whitman, do you recall signing the deed? Vaguely. They put papers in front of me. I remember holding a pen, but my hand was shaking. Matt helped steady it. He physically guided your hand? Yes. Thank you. No further questions. Sandra Cross approached for cross-examination. Her smile was polite, but her questions were sharp. Mrs. Whitman, you testified you had the flu. Did you see a doctor? No. So we only have your word that you were ill? I know when I'm sick, of course. But without medical documentation, we can't verify the severity. Can we? I was in bed for 3 days. Did anyone else see you during those 3 days besides your son and daughter-in-law? No. So, again, only your word. Donovan objected, argumentative. Sustain. Miss Cross, move on. Mrs. Whitman, you testified that you vaguely remember signing. If you remember signing, doesn't that suggest you were conscious and aware? I was conscious. I wasn't coherent, but coherent enough to hold a pen and write your name. With help? Help you requested, correct? Because your hand was shaking? Yes. Thank you. No further question. I stepped down feeling like I'd lost ground. Donovan squeezed my shoulder. You did fine, now we bring in the expert. Dr. Hoffman took the stand, credentials read into the record. She presented her analysis with scientific precision, overlaying signatures, pointing out discrepancies, explaining the tremors and the stroke patterns. In my professional opinion, this signature was made under duress or physical impairment. It does not match the natural characteristics of Mrs. Whitman's normal handwriting. Sandra Cross, cross-examined. Dr. Hoffman, isn't it true that people's handwriting changes when they're ill? Yes. So the tremors you identified could simply be evidence of Mrs. Whitman's flu, not coercion? The tremors? Yes. But the structural differences, the size of letters, the direction of curves, those don't change with illness. Those suggest external influence, or they suggest an elderly woman with shaky hands. Mrs. Whitman's other signatures show no such shakiness. Other signatures from when she was healthy. They went back and forth. Each answer from Dr. Hoffman was countered with an alternative explanation. By the time she stepped down, I wasn't sure if we'd proven anything or just muddied the waters. Then Sandra Cross called Kate to the stand. Kate wore a navy suit, modest jewelry, an expression of concerned competence. She spoke clearly, confidently, like someone who'd rehearsed her testimony. Miss Cross, can you describe what happened on April 5th? Matt and I went to check on Betty. She'd called saying she was sick. We brought soup and medicine. While we were there, she asked us about estate planning, said she'd been thinking about what would happen to the house when she died. She initiated the conversation. Yes. She was worried about probate, about leaving Matt with a complicated estate. She asked if there was a way to simplify things. What did you tell her? That we could help. I have a cousin who's an attorney. He'd mentioned that transferring property before death can avoid probate issues. I told Betty we could arrange that if she wanted. In her response, she said, yes, please do it. She wanted it handled while she was still alive to make sure it was done right. I wanted to scream. It was all lies crafted to sound reasonable, supported by a notary who'd conveniently moved to Arizona. Sandra continued, was Mrs. Whitman impaired when she signed? She was sick, yes. But she was lucid. She read the documents. She asked questions. What questions? She wanted to know if she could still live in the house. I assured her she had a life estate, meaning she could stay as long as she lived. And the notary verified her competence. Yes, the notary, Ms. Rodriguez, spoke with Betty privately, asked if she understood what she was signing, if anyone was forcing her. Betty said yes, she understood, and no, she wasn't being forced. Thank you. No further questions. Donovan's cross-examination was aggressive. Mrs. Whitman, you testified that Betty asked about estate planning, but you didn't bring any estate planning documents, did you? You brought a property deed transfer. That's a form of estate planning. Is it? Or is it a form of property theft? Objection. Sustained. Mr. Pierce rephrase. Did you tell Mrs. Whitman she was transferring ownership? Or did you tell her she was updating beneficiaries? I told her the truth. Then why does she remember it differently? I can't speak to her memory. Convenient. You also testified that the notary verified Betty's competence? Where is this notary now? Arizona. She moved for personal reasons. How convenient. So we can't question her directly about what she observed? She provided a sworn statement. A statement prepared by your cousin, the attorney? Kate hesitated. Yes. So your cousin, who benefits from this transfer by providing legal cover, also prepared the notary's statement. He didn't benefit? He wasn't paid, but he helped you steal a house. Objection. Your Honor, this is harassment. Sustained. Mr. Pierce, control yourself or I'll hold you in contempt. After Kate stepped down, the judge called a recess. I sat in the hallway with Donovan, watching Matt and Kate whisper with their lawyer. What do you think? I asked. I think it's close. The handwriting expert was strong, but their testimony was coherent. It comes down to credibility. Who does the judge believe? What if she believes them? Then we appeal. But Betty, let me ask you something. If you lose this house, what will you do? I thought about it. I'll find somewhere else to live. I'll survive. But I need to know I fought. I need to know I didn't just let them take it. Good. Because whether we win or lose today, you've already proven you're not someone to be managed. The judge returned. We went back into the courtroom. I've reviewed the evidence, Judge Kensington said. This is a difficult case. Both sides present compelling testimony. However, I'm troubled by several factors. My heart raced. First, the handwriting analysis shows clear discrepancies. Second, the notary who allegedly verified Mrs. Whitman's competence is conveniently unavailable for questioning. Third, the defendant's story that Mrs. Whitman initiated this transfer while sick with the flu strains credulity. That said, I cannot conclusively prove coercion. What I can do is order an independent review of the transfer process. I'm appointing a guardian ad litem to investigate the circumstances surrounding the April 15th signing. Until that investigation is complete, the property transfer is suspended. Mrs. Whitman retains full ownership. I exhaled. Not a win, but not a loss. A chance. Sandra Cross stood. Your Honor, we request that the court consider the financial burden this places on my clients, who have already invested in maintaining the property. Your clients attempted to transfer property from an ill woman who didn't fully understand what she was signing. Any financial burden is a consequence of their actions. Judge Kensington looked at Matt and Kate. And let me be clear. If the guardian ad litem finds evidence of fraud or elder abuse, I will not only reverse this transfer permanently, I will refer the matter to the district attorney for criminal charges. The courtroom went silent. Court adjourned. The guardian ad litem was a retired social worker named Dorothy Chen. Mid-60s, sharp eyes, no-nonsense demeanor. She spent 3 weeks investigating, interviewing me, Matt, Kate, neighbors, even Joyce. She reviewed medical records I didn't know I had, calls to my doctor's office in April showing I'd asked about flu symptoms. She tracked down the notary in Arizona and interviewed her by video call. When Dorothy finally submitted her report, Donovan called me immediately. "Betty, you need to sit down." What did she find? The notary admitted she never actually spoke to you alone. Kate was in the room the entire time, and Kate paid her $500 cash, 3 times the normal fee, to notarize the documents quickly without asking too many questions. So Kate bribed her, essentially. The notary says she felt uncomfortable but needed the money. She's willing to testify that the process wasn't properly executed. What does that mean? It means we win. Judge Kensington's ordering the transfer reversed. The house goes back in your name. And she's referring the case to the DA for possible fraud charges. I sat down, legs suddenly weak. It's over. The property dispute is over. The criminal investigation is just beginning. The final hearing was short. Judge Kensington read Dorothy's findings into the record, her voice crisp with disapproval. The evidence clearly shows that the transfer was obtained through misrepresentation and improper notarization. Mr. and Mrs. Whitman took advantage of Mrs. Betty Whitman's illness to execute a transfer she neither understood nor would have consented to if properly informed. This court finds the transfer void ab initio, void from the beginning. She looked at Matt and Kate. You will return all documentation to Mrs. Whitman. You will file the necessary paperwork with the county to restore her as sole owner. And you will pay Mrs. Whitman's legal fees. Sandra Cross started to object, but the judge cut her off. Save it, counselor. Your clients engaged in elder financial abuse. They're lucky I'm not holding them in contempt. After the hearing, Matt tried to approach me in the hallway. Mom, I'm sorry. You didn't think I'd fight back, I finished. You thought I was too old, too trusting, too easy to manipulate. That's not fair, isn't it? You came to me when I was sick, put papers in front of me I couldn't read properly, and walked me through signing away my house. What would you call that? Kate stepped forward. Betty, we were trying to help. You're getting older. You thought you'd get the house early? Skip the waiting? Skip the inheritance? Just take it while I was too sick to understand. We gave you a life estate, which you could have revoked any time, which would have made me a tenant in my own home. I looked at Matt. I raised you better than this. I know. Mom, I'm sorry. Really? Can we fix this? I thought about it, about the 43 years in this house, about the memories that lived in every room, about the son I'd raised who'd grown into a stranger. I don't know. Right now, I need you to stay away, both of you, until I figure out who you really are. They left. I watched them walk down the courthouse steps, Kate's hand on Matt's arm, already planning their next move, probably. Donovan stood beside me. How do you feel? Tired? Relieved? Sad? The DA's reviewing the case. They'll probably offer a plea deal, restitution, probation, community service. Matt won't go to jail, but it'll be on his record. Good. You sure? He needs to understand that actions have consequences, that you can't steal from people and call it helping. We walked to my car. The November air was cold, but the sun was bright. Thank you, I said, for believing me. Thank you for fighting. Most people in your position give up. I couldn't. This house is all I have left of my marriage, of my life. I wasn't going to let them take it. Over the next weeks, the legal paperwork processed. My name returned to the county records as sole owner. Matt and Kate's names vanished like they'd never been there. Joyce came over the night it was all finalized. We sat on the porch drinking wine, watching the neighborhood settle into evening. You did it, she said. We did it. I couldn't have fought this alone. What now? Now I change my locks, update my will, make sure this never happens again. And Matt, I sipped my wine. I don't know. Part of me wants to forgive him. He's my son. But another part of me knows he's not the child I raised. He's someone who tried to steal from me. I'm not sure how to reconcile those two things. You don't have to reconcile them. You just have to decide what you can live with. I can live with boundaries, with distance, with a relationship that's conditional rather than automatic. That's fair. Is it? I don't know. I just know I can't go back to trusting blindly. Trust has to be earned. And right now, Matt's in debt. The DA offered a plea deal a month later. Matt pled guilty to attempted financial exploitation of an elder. He got 2 years probation, 500 hours of community service, and had to pay back my legal fees, $23,000. Kate was charged separately. She pled to a lesser charge, fraud, got 1 year probation. They both had permanent records now. The local paper ran a small story. Local woman fights elder abuse, wins. It made me sound like a hero. I didn't feel like a hero, just a woman who'd refused to disappear. 6 months after the case closed, Matt called. Mom, can we talk? About what I did. About how to fix it. We met at a coffee shop, neutral territory. He looked different, thinner, older. His real estate license had been suspended pending an ethics review. Kate had moved out. I've been seeing a therapist, he said, trying to understand why I did what I did. And I think I convinced myself you were declining, that you needed protecting, that taking the house early was helping you. That's what you convinced yourself. What do you actually believe? He looked down. I believe I wanted the house. Kate wanted the house. And we told ourselves a story that made it okay to take it. At least you're being honest now. I'm trying. Mom, I know I don't deserve forgiveness, but I'm asking anyway. Can we start over? I thought about the question I'd asked Donovan months ago. What would I do if I lost the house? The answer had been, survive. Now the question was, what do I do with a son who tried to take it? We can't start over, I said. But maybe we can start something new. Something honest. What would that look like? It would look like you respecting my boundaries. Not asking for anything, not managing me, or making decisions for me. Just being my son. If you remember how I'm going to try, then try. But understand, I'm watching. Trust isn't given anymore. It's earned. And you're starting from zero. He nodded, I understand. We talked for another hour. Nothing deep, just surface conversation about his job search, his separation from Kate, his probation. It felt awkward and fragile, like learning a language I'd once known but had forgotten. When we parted, he hugged me. I let him, but I didn't relax into it. Not yet. And the house still stands. My name still sits on the deed. Every morning I wake up in the bedroom. I've slept in for 43 years, and I remember that it's mine. Matt and I have a relationship now. Not the one we had before, not the one I imagined, but the one that's possible after betrayal and legal battles and slow rebuilding. He comes by once a month, helps with yard work. We have dinner. We talk about safe things, weather, news, his new job. We don't talk about the house unless I bring it up. His probation ended. His record remains. He's rebuilding his real estate career slowly, working for someone else now instead of running his own business. Kate remarried, moved to another state. I never saw her again. I updated my will. The house goes to a nonprofit that helps victims of elder abuse. Matt will inherit my personal items and some savings, but not the house. Not anymore. He knows. Accepted it. Said he understood. I believe him? Mostly. Joyce and I still have wine on the porch. Talk about life, about aging, about the strange mathematics of family. Do you regret fighting? She asked one evening. No, I regret needing to, but not fighting. What did you learn? I thought about it. That being someone's mother doesn't mean surrendering your rights. That love doesn't require sacrifice of self. That sometimes the kindest thing you can do is set a boundary hard enough to hurt. That's a hard lesson. Most good ones are. Last week, I found the original county records envelope. The one that started everything. I'd kept it in my files. Evidence of the day I woke up. I looked at those words again. Previous owner, Betty Whitman. But they were wrong. I was never the previous owner. I was always the owner. I just forgot for a while that ownership requires defense. My name is Betty Whitman. I'm 69 years old. I live alone in a house I fought for and won. It's not a victory that feels triumphant. It's quieter than that. It's quieter than that. Just the satisfaction of knowing that when someone tried to erase me, I pushed back. And I'm still here.